Welcome, everyone. I'm Jamie Sweet. I'm the Associate Director of Education and Entrepreneurship here at Pennovation Works. Today we have Cynthia Dahl, who is the Director of the Detkin IP Clinic, which is a teaching law firm at Penn Carey Law, and it gives students the chance to help clients set and implement IP strategy. My colleague Christy Carabello is here. She can attest to the work that they do at the Detkin Clinic. And Cindy is here to talk to us about trademarks. So I'm going to hand it over to her.
Fabulous. Thank you for the intro. Lovely to speak with all of you. I'm going to share my slides. Okay. I have a lot of information that I can go through in the next hour. We have an hour, right? Okay, good. But I want this to be relevant for you, and we're a fairly small group. So I want to encourage you to interrupt me with any of your questions as we go, because I want them, I don't want you to forget your questions, and I want to make sure that when I answer them, if I haven't been clear in what I've been saying, that I address that right away. And I guess, Jamie and Christy, if I can ask you guys to keep an eye on the chat in case I miss something, please let me know if there's a question and I will stop. And then I'm assuming that there may be some time at the end as well for general questions. And I can tell you, I guess I'll start by telling you a little bit about the clinic, because that will sort of give you the context for everything that I'm going to be saying. So the clinic is a free law firm on campus. We handle Penn clients, but also non-Penn clients as well. A lot of our good work comes from either PCI, and I saw Lena on the call, or from Pennovation. And so we're very grateful for the partnership that we have with both of those institutions. But we also do help general startups from Philadelphia. And we are the IP clinic. There's also an entrepreneurship legal clinic that I was just chatting with Reno about when some folks were getting on the call. But both of us do the same thing in that we offer free legal services to clients. There are a lot of entrepreneurial resources at their clinic website. And the very last slide in this presentation has my clinic's website. So you can get into both my clinic and then the Entrepreneurship Legal Clinic if you're interested in finding out more about becoming a client of either of our clinics. And finally, my clinic also offers office hours out of the Free Library of Philadelphia. And so if you've just got quick questions and you just want a 45-minute confidential consultation with two students and me to talk about your particular issues, please reach out to me and I can tell you how to sign up for those. Okay. Happy to answer any questions about the clinic, the kind of work that we do, but broadly, it's transactional intellectual property work. So we don't do litigation, but we do all kinds of contracting and deals and protection strategy for early stage entrepreneurs. Okay, but the reason that you're here today is for us to have a discussion about trademarks. And so briefly, quickly, I wanted to lay out the kinds of topics that I'm going to be covering over the next hour. First, I'm going to give you a broad background on what is and what is not a trademark, because there's a lot of confusion out there about what trademarks can do and what formal trademark protection covers. So we're going to start with that. And then I'll give some guidance in how to choose a strong brand that can be protected through federal trademark if that's the way that you want to go. Then I'll talk quickly about how to search availability of marks in case you have several marks that you're considering and you'd like to see if a mark is clear. Then we'll talk about when actually it's worth it to file an application for federal rights and when maybe you should wait. And then should you go ahead with filing an application, I'll talk a bit about what the application process is like, how much it costs, how long it takes, pitfalls that happen along the way. And then I'll end with how to use your trademarks correctly over time, build brand equity, and then to protect against infringement. So a lot to cover in an hour, but we'll go through it. And then again, please interrupt me as you've got questions. Okay. So just as an a leveling of everyone's sort of context here. Our clinic talks a lot about these different IP protection tools that we have, and these tools cover different subject matter for different lengths of time in different ways. And I'm happy in the clinic, through the clinic, to talk to you about patent or trade secrets or copyrights. But we're going to spend the time today talking about the fourth tool, trademarks. Patents cover processes or methods and ideas. Trade secrets cover mostly data and confidential ideas and information that your company has. Copyright covers fixed expression. Trademarks cover brands. Any source identifier where the consuming public can understand that the service or good that you put out in the world comes from you. So now I'll talk more about that. So trademarks or service marks, you may have heard both terms, are brand identifiers. When it is a brand identifier for a good, we call it a trademark. When it is a brand identifier for a service, it's technically a service mark. But for the rest of the presentation, I'm going to call both of them trademarks, just for simplicity. So trademarks protect brands. They don't protect your company name, and they don't protect your domain name. These are different registrations for different purposes, and trademarks protect the source identifier that is your brand. Trademarks can take different forms. There are word marks, like for example, Nike. There are logos, like the swoosh. There are composite marks that have both a logo and a word mark all put together. But trademarks are broader than that and can cover any source identifier, like a smell or a sound. You can think about Tiffany blue. You can think about the three chime aspect of the NBC. NBC. I don't even know if they do that anymore. I think I'm dating myself a little bit. But anything that is a source identifier can be protected through trademark. We have several different kinds of trademark rights, or different buckets of trademark rights. When you are using a source identifier in public, you automatically get common law rights. If you actually apply for additional rights, you can get those federal rights. You've seen, as you walked through the supermarket, TM or SM after a good on packaging, for example, TM. That indicates that someone does not yet have federal registration. They may be in the process of getting that federal registration, or maybe they haven't even applied, but they've got common law rights. Once you have the R in the circle, you've got that federal registration. Okay. So let's move on then to how do you choose a mark that is good mark, legally protectable mark. There are a couple things that you should be thinking about. First, the mark should be unique. Remember, I've talked about this as a source identifier, and so it should be something that only stands for you. And there's a spectrum of distinctiveness that ranges from an arbitrary or a fanciful mark all the way to generic marks. And the arbitrary, fanciful side of the spectrum is more easily legally protectable. Easier to go through the USPTO, the US Patent and Trademark Office, if you want to file a trademark application, and easier for you to basically carve out a marketing niche for yourself because other people wouldn't be using similar marks. So an example of an arbitrary mark, once upon a time, Xerox was arbitrary. Now it has so much brand equity in it that if I say Xerox, you know exactly what I'm talking about. But when they coined that term in the beginning, nobody knew that Xerox was going to be related to copying machines. That's an arbitrary term, but it's a very strong trademark because once the consuming public started to affiliate that mark with copying machines, it was very memorable. Sorry, that's a fanciful mark. An arbitrary mark is Apple for computers. It has meaning, but it's not regularly associated with the good that's put out there. So fanciful and arbitrary marks are both very strong. The second strongest mark is a mark that is suggestive. The classic mark that they use as an example here would be copper tone. So copper tone is suggestive of what the product does or is. But if I say copper tone, you don't necessarily associate it with sunblock yet. Over time, people can start to associate that. And then, so that's a strong mark, suggestive. Descriptive marks are next on the scale, and descriptive marks are not protectable through federal trademark yet. They are very descriptive of what the good or service is. Something like creamy cold for ice cream, something like that, would not be an initially protectable mark. Over time, if people stop thinking about it for its meaning, just like creamy cold, but they start thinking about it in terms of ice cream, then it can actually mature into getting, being able to be protectable. And then generic marks are marks that are so close to what the good or service is that the USPTO determines that nobody should have exclusive rights to that. Other people might need to use that name to describe their product, and so you can't have the ability to keep other people from using that mark. Okay, so distinctiveness. The more distinctive the mark is, the more easy it is to protect it from a federal trademark standpoint and to also fend off other would-be users of that mark. Likelihood of confusion. If somebody else is already using the mark that you would like to use, or a mark that could be confused with your mark, then the USPTO is going to deny your ability to get exclusive coverage over that. So the likelihood of confusion standard is what we use when we are clearing marks to see if a mark is available or not. There are a few other no-nos that the USPTO has determined, can't be trademarks. Fewer than there used to be because of a couple of Supreme Court cases, but basically you can't get exclusive rights to use somebody else's last name for your good. They should have the ability to use that name, and so you can't get that. Surnames are difficult because many people might have the same last name, so even if it is your last name, you have to go through some additional hoops before you can actually protect it. Not the same for first names. And so somebody always raises Kim Kardashian to me, but Kim Kardashian is able to get that mark as a trademark because it has both first and last name. It is her name. And you can't fool the consuming public. Like you can't call your sparkling wine champagne if it's not from a certain region in France, for example. So there's a whole category of misdescriptive marks that are not allowed to be protected. So choosing a strong mark, there are a couple things to think about. Of course, a lawyer can guide you through all of this, but these are sort of the top three. Pause there for any questions. I feel like I've been talking a lot. Any questions? Okay.
I have a question. It's Christine Rowan from Visa Watch. If, like you say, you can't use you couldn't trademark your company name, but if your company name comes with the logo, kind of like with Nike with the swoosh, is that trademarkable? I'm trying to figure out. Or is
So
it
what I'm
product
saying,
name or whatever?
Thank you for raising that again, because it's such an important point, and I want to take another chance to explain that. So if your brand is the same as your company name, for example, Hyundai is both the name of a company and a broad brand for their cars. If I mention I own a Hyundai automobile, that is brand. If I say that I bought a car from the company Hyundai, that is not a brand use of that word. That is the name of the company. So if your brand is the same word as your company's name, you may trademark that word. But what you're trademarking is a brand. And where entrepreneurs sometimes get confused is they feel like unless they trademark, they can't have the company name Visa Watch. And that's of course wrong. You can have the company name Visa Watch. If you're not using it to indicate your good or your service, that is a different registry. You are telling the state of Pennsylvania, for example, that you are operating under the name VesaWatch. And that is a company registration issue. If you happen to also put out a service or a good under the name VesaWatch, then apply for a trademark registration under VesaWatch if you want federal rights.
Okay, they're very helpful. That Hyundai example is very helpful. Thank you.
Good, good. And Hyundai, of course, has the Veracruz, the Santa Fe. These are other brands that they have underneath. I use the Hyundai and Hyundai because they also have a brand in addition to the name of it's the same as the name of the company. Good. Any other questions? Okay. Digging more into the likelihood of confusion standard because it's important and it will lead naturally into the next step, which is to search the mark. I wanted to just talk about who are we talking about when we're talking about being confused and what does a likelihood mean anyway? What is that standard? US trademark law is not actually about the companies that do the branding, it's about the consumer. And they're trying to protect the consumer who's walking through a store and wants to make sure that the product they bought before that they liked is the same product that they're buying now. And so you have to think about it from the consumer's point of view, not from the owner of the trademark's point of view. So the test is a consumer likely to be confused if there's a certain mark and there's another company that is using their mark? Are they going to be confused about the source of the good or the service? So when we do an analysis about whether or not another mark from another source is going to be confused with your proposed mark, we look for similarity first in the sight and sound and connotation of the two marks. So for example, you've got McDonald's, very strong mark out there, and I would like to have McDougal's. And I would like to sell hamburgers under McDougal's. So the first thing we do is we would line up McDougal's versus McDonald's. And we'd say, all right, site, the MC is common, but McDougal is also a last name. McDonald is a last name. Maybe the consuming public could tell them apart. But we think for sight and sound and meaning, the connotation. What are we doing when we're comparing the marks, particularly if you've got one mark? I mentioned that you can trademark a word, or you can trademark a logo, or you can trademark a combo. Like, I'm going to go back to you, Christine. I see VesaWatch has a logo underneath its name. So if we were to protect the whole package there, that's called a composite mark because it has a word, a literal aspect, but it's also got a picture. So what if we were to compare VesaWatch with the logo under it versus, I don't know, Vika Watch, just a word? What we would be comparing is your whole thing, VesaWatch plus picture versus Vika Watch. So when you compare, you don't just pick out VesaWatch and Vika Watch if you have a composite mark and it's not a word mark trademark. So whole mark to whole mark. But then you would also look at the most important part of the mark. And I see your logo, but VesaWatch comes first. And VesaWatch is a little bit bigger. And your logo is not incredibly detailed. And so probably the trademark examiner would say the most important part of your composite mark is that literal element, that VesaWatch. So if there were Vika Watch versus VesaWatch, that would be good for you because you would be able to say VesaWatch is the more important part, and that is much closer to Vika Watch than the whole thing together. Does that make sense? Okay. We're also looking at what goods and services are sold under the other mark and under your mark. So McDougal's for hamburgers is closer to McDonald's than McDougal's for computers. And so if I wanted to roll out McDougal's for computers, there's probably less of a likelihood of confusion because of what I'm trying to do with the mark. Okay. So when you are doing this search, how do you do it? How do you know who else is using what marks out there? Well, if you go into uspto.gov, again, that's the United States Patent and Trademark Office, they have a new cool AI-powered search tool called Trademark Center. They just rolled it out about, I don't know, 3 months ago. So it's actually pretty easy and intuitive to use. What do you find under the USPTO.gov trademark? Federal applications and registrations. It doesn't include state application and registrations, and we'll talk in a second about the importance of Googling your mark, but it basically doesn't cover any, people that have not applied. So what's it going to give you? It's going to give you a good result, but not a complete result. But it's important to start here because you want to know who's most concerned about protecting their trademarks. And the USPTO will show you the people that have gone to the trouble of filing a trademark application. There are some other commercially available tools out there that are a little bit broader, but for your uses, at least the USPTO.gov trademark search, Trademark Center, is free. And so to the extent you don't have access to some of these other commercially available tools, this at least will give you a pretty good answer. When you plug in your name, you should, of course, start with the identical marks because there's a much greater likelihood of confusion if the site, sound, and connotation, remember, if the site is exactly the same. So if you would like McDonald's and you go in there and you type it in, you're going to get the hamburger maker McDonald's mark. And that's probably your most important result. So definitely go in there and look for identical marks first. But because likelihood of confusion is a sliding scale, and we're looking for the same or similar marks because the consuming public could be confused by a non-identical mark, you also want to search some variations on your mark to see what comes up. The Trademark Center does some of the work for you now because it's AI powered. And so it probably will give you hits that, for example, add an S on the end to your mark, or change E's for I's or I's for Y's, so that even if it's not exactly your mark, the sound would be similar and the site would be close. But you want to make sure that your search is a little bit broader than just your identical marks because there can be a likelihood of confusion for marks that are similar to yours as well. The USPTO, when thinking about likelihood of confusion, if they cite another mark against yours, they're going to go to the way that that other party described their use. And we'll talk more about when we get to how to file your own application, how you come up with a good description. But if the description of goods and services that that other mark, the prior mark, has is broad, that's hard for you because broad descriptions sweep in a lot of different nuanced uses. For example, if you've got a party that, let's say that they are creating videos, short videos that they put online that are travel videos. And their description of goods and services says production of motion pictures. Suppose you want to do something like videos in the realm of, some social justice, like criminal justice or something like that. And you're using your videos for completely different purposes, educational purposes. You're not selling them at all. The fact that they have a description of goods and services that is like production of motion pictures, that's hard for you to overcome because you are also producing technically motion pictures. And so when the USPTO cites other marks against you, importantly, they're going to go off the description of goods and services that has been assigned to that mark. And so you have to decide whether or not that description is broad enough to sweep yours in or not when you're thinking about a likelihood of confusion. I talked about different levels of rights and how people get common law rights just because they're using a mark in commerce. So under US law, you get trademark rights because you're using, and the first person to use the mark gets what's called senior rights, and they have the ability to shut down later users under that likelihood of confusion standard. Even if you don't file for a federal trademark application, if you are using, you can stop other people from using a mark that is the same or similar to yours. Common law uses, though, only give you the right in certain areas of the country for whatever you're using before that junior user starts. So you do need to look at Google to see if other people are using your mark or a similar mark that didn't apply for the USPTO coverage. So don't forget to search Google for those common law uses. The benefit to getting a federal trademark registration is that you automatically have rights across the country. So it's not just where you're using the mark, and other people can find you more easily. So it's a deterrence factor for infringement, and you get increased damages. So that's why you might want to go ahead and file a federal trademark application. But for your purposes, when you're choosing a mark, you want to know who's already using it out there, even if they haven't filed a trademark application.
Can I ask a question,
Yeah.
Cynthia? So what constitutes use in this internet world where, I mean, if you've got it on the internet and you're using it, on your website or whatever, or do you have to actually be selling into the market? What constitutes use?
So I think in your question, you've got two really important concepts. And the first is, what does it mean to use a mark? And you don't have to make money, but you do have to have your good or service available out in the world for you to be using. So we get questions a lot of times when people are in beta. You've got a closed beta use or an alpha use, and you only have certain people that are using your product or your service. Are you using your brand? And the answer is usually no, if it's not an open beta. If anybody could sign up for your beta and get use of your good or service, then it can be use. But basically you have to think about, could a stranger use your good or service? Could they find you and could they use it? That's use. But also in your question was about jurisdiction. Common law use, that whole concept sort of grew up around pre-internet, around like very local use, like, a pizzeria in a small city in New Jersey, right? So someone could use Angelo's Pizzeria in New Jersey and someone else could use Angelo's Pizza in California, and there would be no likelihood of consumer confusion unless you miraculously went to New Jersey and California and bought pizza at both places. Then you might think that they were affiliated, but probably not. But now that we've got the internet, what is use if you put it up online? And the way that the courts have thought about this is, who are you trying to engage as your customer? If you truly have a national audience and you're trying to get customers nationally, then that is a nationwide common law use. But if Angelo's Pizzeria, small brick and mortar, has a website and they're really only a Northern New Jersey pizzeria, even if they have a website, basically so you can order online for delivery or whatever, they're not really marketing to people in California because they're not going to be delivering their pizza to California. And so they sort of look at that use and who you're trying to engage as your customer.
Okay, cool. And so that's for the common law piece of it, but
Right.
you could apply for the trademark.
You apply federally for a trademark registration and a federal registration, and it's a presumptive cross the nation group of rights. So even if Angelo's Pizza only sells pizza in Northern New Jersey, if they wanted to spend the money for nationwide federal trademark registration, they would lock down Angelo's Pizzeria across the country.
Okay, and you may be getting to this, but the timing for those of us who are not yet in market, if we want, I guess the cost benefit of locking down a trademark ahead of that. I am assuming we could apply ahead of that, or do we have to wait till we're actually in market?
Great question. And yes, that is going to be, I will talk about that with applications, but let's just answer it quickly now. Yes, in the United States, although we are a use-based jurisdiction, you can indicate that you would like to have rights in this mark. And once you can show that you're using it, your rights will go back to the date that you filed that indicator application. So for example, Angelo's Pizza, not yet in business, but they really like the name and they'd be really crushed if anybody else used it. They file a 1B application And as soon as they open their doors and they're making pizzas for the consuming public, they will get rights that date back to their application, even if they don't start using the mark for a year.
Okay, cool. Thanks.
Yeah. Okay. So I talked about how you do the search. You may get a whole lot of hits. So what do you do to figure out if any of the hits are problematic? I've talked a lot about similarity in sound or sight sound connotation. So you look at that first, and basically the closer it is to your mark, the more you should be thinking about them as being a potential obstacle. But you also, of course, look at what they're selling. And the US Patent and Trademark Office divides the universe into 45 so-called classes. And if the mark that is the problematic mark is in your class, it is more problematic than it is in a different class. Going back to McDonald's and McDougal's, if I am selling hamburgers, that's more of a problem than if I'm selling computers. They are strictly in different classes. There are food classes, and then there are computer classes. So classes and industries are important. Classes are a little weird though, because I don't know how they came up with the different classes, but class 9 has both sunglasses and all things hardware, computer hardware in it. So they're not incredibly intuitive. You just have to actually search and know. And they're, if you're interested in knowing more about how to figure out what class you're in, I'm happy to talk about that. And it's not strictly, you can't shut it down necessarily if you're in different classes, because there are some classes that are related. Computers is a great example. Class 9 is all things hardware, but all things internet are class 42. So if you offer a service through the internet, that might put you in class 42. And if your service is offered through a computer, the hardware might be in class 9. But you can imagine where some companies offer both. And so if you are in a related class, you have to consider marks in that other class as well as being somewhat close to yours. But our good rule of thumb is to think if we are in a different class, that is less of a problem with a little asterisk. Okay, the sophistication of the mark. McDonald's been around for a really long time. They are pretty militant about protecting their mark. So the longer they've been around, the more litigious that company is, the more you start to think, maybe I don't want to encroach on them. The activity of the mark. How often have they fought the mark? There's a way to sort of check that to see how many people they have actually. You can't see private cease and desist letters, but you can see formal adjudications, and you can see just how litigious they are. There are some companies that are really notorious, like Disney and Monster. You just don't want to go there because they're just nasty. And the status of the mark. So let's say you found a mark that you're quite worried about. You might be able to check into the status of the mark and to figure out that they're not as much of a threat as you thought. For example, if they're just an application, and I mentioned how you can apply on an intent to use basis, but they've been on file as intending to use this mark for 3 years, and they haven't actually proven their use. They might be timing out, and maybe they've lost interest in that mark. Or even a mark that's issued, I'll talk about this in a couple of minutes, but you actually have to maintain that mark and pay for that mark over time. And so sometimes people neglect to pay their fees. And if they neglect to pay their fees, that mark could become canceled. So you want to look and see if there are any indicators that this mark is actually not in use anymore, or might be on the ropes. Maybe they've gotten 2 office actions and it's close to being abandoned. So you want to check into the status of the mark too before you panic. Okay, so let's assume you've picked a good mark and you've searched it and nobody else worries you. Now you should think about whether or not it's worth it to file for a federal trademark registration. I've mentioned that you don't want to file a trademark for something you're not using as a brand. If it's just your company name, you don't need to file anything. If you're only using it locally, you're not an online presence, you don't expect you're going to have consumers from a different state, maybe you can just rely on common law use. Do you really like the mark? And are you sure that it's not going to change? If the answer is no, if you're early stage and you're not so sure about it, maybe you're not ready to spend the money on a federal trademark. Let's wait and see how it shakes out. Are you in use yet? If you're not in use yet and you're not sure if it's, if you're not sure of the future of this particular good or service, you're not sure of the brand, then maybe you want to hold off a little bit. And of course, if you've got a number of hits that are close to your mark when you've done the search, maybe you're not ready to file that federal trademark yet. You want to build up some brand equity before you file the mark or consider a different mark. So you should stop and not necessarily go ahead with filing for the federal registration until you really think through these questions. Just one quick nod to a way that a lawyer can help you. If you are concerned about a number of marks that are close to yours, you can reach out to a lawyer and say, hey, how much risk do I have here? And sometimes they may give you what's called a trademark opinion letter. This is a simulation that I run within my clinic when I'm teaching students how to do this. But the mark that was presented to us, in simulation here is say hello, 2 words. And then these are the results that came back when we searched it. And, this trademark opinion letter would run down the marks that the attorney thought were closest and most risky, depending on who the applicant was, the current use, and sight sound connotation in the right class. So here's some examples here. The third one down, this F1, say hello, is pretty risky because it's exactly our mark. And we were, let's assume, in class 9. So this is the same class and the same mark. But you also want to look at things like just say hi, say low, or he low, because sight sound connotation, they're close, particularly if they're in overlapping classes. This trademark opinion letter is most helpful if you're going to go ahead with the mark and you want to be able to show that you did your diligence. Trademark opinion letters are not a good idea if there's a mark that's really, really close to yours, and it would become evidence that you went ahead despite a lawyer's best, counsel to not go ahead. So, you don't want a trademark opinion letter in all cases, but you should know that this is something that you can ask for that lawyers can support you on. Okay.
Christine, did you have a question? I saw your hands up at one point.
Yeah. So I have a question about, is there a scenario where you would actually want to file defensively? Like, for example, I have a litigious major competitor, right? If I was gaining, and I've heard if I was gaining traction or they thought I was, could they preempt me? And so would I want to file a trademark to avoid that?
So that's a great strategy for patent, because you don't want them to be competing with you over the same sort of product or the same sort of technology. But remember, you only get rights in the United States if you're using. And so you don't have any rights over, you're talking about like filing for a trademark for a name that you would not use. That's not a good idea, because you will not ever be able to get rights, because you will not ever be able to prove that you're using something you have no intention to use. Plus, when you file those intent to use applications, you're testifying, basically, you're verifying through an affidavit that you do intend to use. So it's false. So you don't want to do that. And also remember that trademarks protect brands. They don't protect the idea under your company. They just protect their ability to use VasoWatch. So if somebody were both copying your technology and potentially copying your name, that's a much bigger problem than just, the filing the trademark application would solve. So.
Got it. But they
Yeah.
could do it. I mean, they could file for my name just to kind of stir the pot, right? And create confusion.
They could file for your name, but if they're not using your name in public, they're never going to get the rights to shut down your use. And if you've already got a senior use of VasoWatch, then you can oppose their application.
Yep.
Officially.
Okay. All right, cool. Thanks.
Rights. Yeah. So let's assume that you go ahead with this application. I'm going to talk to you briefly about what the process looks like. So we've talked about basis broadly. 1A and 1B show, like the 1A application shows you are already using the mark in commerce. 1B is an intent to use basis. You intend to use it. The application type, for 2 more days, there are different kinds of applications. On Friday, they're going to change this in the US Patent and Trademark Office. But I wanted to at least include this here because if you've heard from another lawyer that there's something called a tease and a tease plus, it's actually changing. And that lawyer should be up to date, but in case you hear these terms, that's what's going on. The application, they're moving you to, they're forcing you by money to do a simplified application now. If you want to go forward with an application like we used to be able to file, you're going to have to pay more money. So you do have that opportunity available to you on Friday and after, but you're 99% sure you're going to be doing the application that they're going to force us to do. I talked about classes. You have to choose what class you are marketing in. So are you a good? Are you a service? Are you both? The goods classes are 1 to 34 and services classes are 35 to 45, and you have a variety of choices. When we have an early stage entrepreneur that basically has the money to file in one class, we ask them, which kind of a competitor would you be most angry about if they used your mark? So if you have, for example, both goods and services, you say a person that is selling the same sort of good, would that make you angrier? Or the person that's offering the service, would that make you angrier? So for example, like a Pep Boys that sells both tires and the services of installing tires. Are they more a services company or are they more a goods company? So you choose your class. And then you come up with a description of your goods or services. And that, again, is so important because that shows the boundaries of what you're going to be able to stop other people from doing under your mark. So the broader you go, the better for you. The broader you go, the harder it is for you to be able to convince the US Patent and Trademark Office that you deserve those broad rights. So, the reason I have draft in parentheses is because back to application type, they're forcing people to take predetermined descriptions of goods and services that the USPTO has come up with and prints in their manual of, ID manual. The manual of acceptable goods and services is strictly what it's called. So if you want to draft your own description of goods and services, you can. You'll pay an extra $200 per class per mark, and then you can draft it yourself. But they would really like to streamline this, and so they're asking us now for a lower priced application to use one of their descriptions. If you have a logo aspect, there's an extra little hoop you have to go through where you have to write in what the logo looks like. Not applicable if you're applying for Word. You have to actually show a specimen. So a specimen shows the way that you are using this mark in commerce already. Of course, if you're filing a 1B intent to use, you have no specimen because you haven't started using it yet. But if you're filing that use-based application, you have to show a specimen. What is a specimen? It can be a photo of your good with your mark on it, if it's a goods mark, or it can be web grab from your website if you sell your good on your website or you make your services available through the internet. But it has to show your mark, the good or service, and that it is in commerce, those three things. And if you can use 2 different specimens or 3 different specimens to get at all 3 of those, you don't have to come up with only one, but the important thing is your specimen package has to show mark, good or service, in commerce. And as of, actually 18th is Saturday. As of Saturday, it's going to cost for trademark applications $350 per mark per class. So 1 mark, good and services classes, $700. By the way, this is government fees. This is not lawyer fees. Lawyer fees, they'll put, another $1,500, $2,000 on top of that. Was there a question? Okay. Okay. Takes about 8 months for the USPTO to get back to you. The examining attorney is looking for all those things we talked about before: descriptiveness, likelihood of confusion, if it's a proper trademark at all. If they find any problem, they will issue what's called an office action. You have 3 months to answer them, and office actions, some of them are easy to answer, some of them are difficult to answer. It depends on what they've said about your mark. You can file an answer, and then you have one more chance with a second office action. Or if you resolve it, or you don't get an office action at all, your mark proceeds to a publication period. The publication period is sort of akin to the old historic, if any person here has a reason why these folks should not be married. It's similar in trademark world. If anybody in the world has a reason why this should not mature to a registration, please say now. You have 30 days basically for the public to answer. And if nobody says anything, then the mark proceeds to registration. Back to Christine's point, if you had a competitor that filed VasaWatch and you definitely had a problem with them getting a registration for VasaWatch, that 30-day period is for you to file a formal objection. It's called an opposition. If you file on an intent to use basis, remember you can't get the rights until you use. So your mark will, after the publication period, just halt. And then you have to file your specimen within a certain period of time and give them a little bit more money. And then your mark will go through the hurdle and will proceed to registration. Incidentally, you have 3 years to show your use. After 3 years, your intent to use application dies and you have to start over again. And every 6 months, you need to renew your intention to use. And it gets increasingly hard because they start to think if you're not making any progress, maybe we shouldn't keep this application live. But you do technically get 3 years from date of filing, from date of notice of allowance to show your use. Okay, good news, you get your registration. How do you take care of your mark and protect it? We tell our clients to think 3 M's: maintain, mark, and monitor. So maintain. There's a little bit too much information on this slide, but basically what you should pull from here is that after you get a registration, you have to be in touch with the USPTO in year 5, in year 10, and then every 10 years thereafter. Year 5, year 10, and then every decade. And basically this is to show that, yes, you do still want the rights. You have to give them a little money, you have to file a form, and then you can continue with your rights. You also have to show that you're still using it, because they would like to, not have somebody sit on a mark that other people would like to be able to use. So that's why they check in with you in year 5, year 10, and then every 10 years thereafter. If you stop answering them, if you don't pay, then your mark goes abandoned. And that's what I was talking about back with that likelihood of confusion slide. Make sure that those folks are up on their payments, because you may be able to get the rights, swoop in and get the rights if their mark expires. So that's maintain. Mark. You have the privilege of being able to use this TM or SM or the R in the circle to show that you own the right to use this mark. It is a good deterrence for other people to show them that you've got these rights. So if you don't have a federal registration, but you are using the mark in commerce, you can always use the TM for goods or the SM for services mark on your website, on your packaging, whatever. You never have to apply to get federal rights to continue to use TM and SM. And I would highly encourage you to do it. You use TM or SM until that day that you actually get the registration federally, in which case you can turn to R in the circle. And that just indicates that you have even stronger rights. Use the trademark in places where you would like to indicate, your branding. And if you can, distinguish the trademark from just general words, however you'd like to do it. All caps, different, italics or different fonts or colors, and of course, using the TM, SM, or R symbol. Where you start to get into trouble is if you use your trademark in ways that are not like a brand. For example, if you use it as a noun. Going back to my Hyundai example, I was careful to say that I drive a Hyundai automobile. If I say I drive a Hyundai, that's actually not good for the Hyundai company, because they would like this to not be synonymous with a thing, but to indicate the source. So trademarks are technically adjectives. If you start to use a trademark as a verb or a noun, it's starting to lose its specialness. It's becoming the thing itself. This has happened to Kleenex. It's happened to aspirin. It's happened to escalator. These were all brands at one point, and now they're less brands because people use them, as the word themselves. Don't change your trademark. If you've got good rights over VesaWatch, for example, do not put an exclamation mark at the end of VesaWatch. Do not call it VesaWatches. Do not change your trademark. You've worked hard to get that brand. For legal reasons and for business reasons, you should be consistent because you're building up equity over time. So that's maintain, mark, and of course, monitor. The more that you can be aware of what your competitors are doing and other people that are using a mark that is the same or similar to yours, you'll be able to shut it down quickly. You have this right. You might as well use it. You have a right to exclude other people from using a same or similar mark for same or similar services. The USPTO does not do this for you. They will stop another party from getting a same or similar mark like a federal registration, but they don't look at Google, and they're not going to send them a cease and desist. They're just going to stop them from getting federal trademark rights. You might actually think that somebody that the USPTO thinks is perfectly fine, you might be more concerned about. So it's up to you to basically monitor and shut down other uses. And this goes for people that are using your mark in an unauthorized way, or are trying to launch just with same or similar marks, or to people that you have licensed to. If they're using it incorrectly, you need to shut it down. If you don't, it becomes much harder to shut somebody else's use down later, because they're going to be able to say, they didn't defend against this party, so, I should have more right. The more marks that are the same or similar to yours that are out in the world, the less strong your rights are to stop their use. Okay, I have 2 minutes left. Are there any other questions? I threw a ton of information at you, so.
Cynthia, Christine had a question in the comment section, and then we have one other that we can save until you're wrapping up. But Christine's question was, how can you provide a specimen if you have a software product? Packaging use?
If you have Norton antivirus, you've got a software product that has packaging. I don't even know if they do it anymore. They don't send you discs anymore. But if it is a hard, an actual good, then you can send them packaging software, maybe TurboTax. Okay. So you can send them evidence of how you sell it. If it is software as a service, or it is a web app, something like that, you would do a screen grab from your website, however somebody finds your software service.
Got it. Thank you.
Yep. There is a helpful in the USPTO.gov website. If you dig a little bit and you go into trademarks, and maybe if you Google like proper specimen for trademark use, there's a list of stuff that would work for goods and stuff that would work for services. That's helpful. Was there another question?
Yes.
There was one more from Alexander from Hydropore. He said, regarding the IP clinic, is there a conflict of interest between Detkin negotiating with Penn regarding IP since Detkin is a part of Penn?
Such a smart question. Yes. Unfortunately, yes. Penn pays my salary, and I want our clients to feel completely sure that everything that I'm doing is in their interest. So we don't negotiate against Penn, but we can represent the company if you are post license or post option, and we can represent Penn over the technology that you would be licensing from Penn, doing information that might be helpful for you. But technically what we're doing is representing Penn, and if Penn decides to share the results of our research with the company, they can. This happens a lot with Penn Ventures companies.
Cynthia, I just for my clarification purposes, so the use of the TM and SM can it only be once you filed?
Nope.
You can use it before even filing anything.
It doesn't indicate a file, an application at all. And
Okay.
so you can use it as soon as you are using the mark as a brand in commerce.
In commerce. Okay, got it. Okay.
Yep.
If you are using the SM or TM, say with your name, the name of your company or your brand, do you have to always use it, or can you use it, say you have a website, put it on the website, but you don't put it on all your collateral marketing materials?
Yes. So first, you'll never use TM or SM with your company name unless it is also the name of your brand.
Right,
So
right.
you use
I got
TM or SM as a brand indicator, a source identifier. But you were asking, sorry, lost the question.
So say if it's let's use an example of say a consulting company where the name is the brand,
Yes,
and you would use SM in that case, right? Because it's a service.
right.
If you have it on your website with an
Hmm.
with an SM, but
Gotcha.
you develop like collateral marketing materials. By that I mean, like you give away a mug or something. And you don't
Sure.
have it on when you do the logo on the mug. Are you then not being consistent in your use of the SM, and that would be questioned in the future, or?
It won't be questioned. It is your privilege to be able to use the SM in order to deter other people from infringing on your mark. If you don't use the SM everywhere, no problem. But my legal recommendation would be to use the SM in the most obvious uses of your brand. So for example, on your trademark, use it on the homepage. If you don't want to use it like deep within your website, doesn't fit, looks ugly. We hear a lot from entrepreneurs that they think it's ugly and they don't want to use it. That's fine. But so use it in the first most prominent, biggest use on your website. And then you don't have to use it for the rest of the website. On a
Okay.
mug, I would put it on your mug, honestly, because you're using the mug as a piece of marketing material.
Okay.
You want to put
Yeah,
out,
yeah,
right?
I would on that, but some things are like, say, a business card. It's just too small. You can't read it. And
Well,
okay,
a business card would probably be about the company name, right? So
yeah,
yeah. So the bottom line is you don't have to use it every time.
okay,
You can use
awesome,
it every time if you want.
awesome. Okay, thanks.
Yeah. Any last questions? I know we're over a couple minutes.
Thank you for answering all my questions.
Absolutely. Thank you for all the good questions and everyone's good questions. And I'm going to make this slide deck available to Jamie and Christy. And to the extent that you want to send it out to the folks that have been on this call, I'm happy to share. And the last slide, again, has my contact information, both my email and the way that you can find the clinic. And so if we can be of help, as your counsel, if you're a full semester long client, or just to meet you in office hours, we'd be delighted. Oh, and we're next accepting clients. We're just closing the current cycle. We're next accepting clients in August for the fall. Thank you.
Well, this was great. Thank you so much. Yes, we can circulate these slides and your contact information with everyone that joined and those who registered. And I will shout out, we have one more IP related program happening next week on Thursday evening. It's our entrepreneurial empowerment series. Phyllis Simon from PCI will be speaking. So hopefully I see some of you there. Thank
Great.
you again, Cynthia. This was fantastic.
My pleasure. Really lovely to meet all of you, and good luck with your ventures. Hope to help you in the future.
Thank you.
Thanks.
Thank you. Bye.
Bye.